Welcome back to our drafting class on deed of assignment. In the previous class, we went through the introductory part of a deed of assignment where we drafted the commencement, date, parties, and recitals. So now what we're going to be doing in this video is to discuss the second part of a deed of assignment, which is the operative part. So we're going to read our scenario once again, and then we'll jump right into discussing the function and how to draft each of the clauses that make up the operative part of a deed of assignment. So let's read our scenario once again. Chief Adeola Gbayi of number 5, Bolo Runduro, Origiri, Ijoka, Akure, Ondo State, Nigeria, wants to acquire the unexpired residue of a seized block of flat duplex located at number 5, Niger Street, Uzi Zone 5, Abuja, from Jumoke Kehinde of number 6, Budoza Road, Ilaramoki, Ondo State. The parties have agreed to a price of 400 million naira. The property is covered by certificate of occupancy registered as number 49, page 59, volume 2018 at the Land Registry, FCT Abuja. The property was acquired by Jumoke Kehinde's late father, Kehinde Adebayo, via a deed of assignment dated the 10th day of March 2008 and duly registered at the Land Registry, FCT Abuja. Upon his death, his executors vested the property in Jumoke Kehinde by a deed of assent dated the 5th day of September 2020. And so now answer the following question. 1. Mention the clauses in the operative part of the transaction between Chief Adeola and Jumoke Kehinde. 2. State the function of each clause. 3. Draft the clauses mentioned in one above. So let's start with the first question to mention the clauses in the operative part of a deed of assignment. So I hope that at this point we are going to be taking it together because by now you should have known it. So first we have the what? Testatum, followed by the consideration clause, the receipt clause, capacity clause, word of grant, all that clause, parcel clause, and Habendum. So we're going to take it one more time. The Testatum, consideration clause, receipt clause, capacity clause, word of grant, all that clause, parcel clause, and the Habendum. So let's start with the Testatum so that we can know the function and then how to draft it. The function of the Testatum in the operative part of a deed of assignment is that it simply introduces the operative part of a deed. So if you are asked to state the function of the Testatum, now all the Testatum serves in a deed of assignment is that it is that clause that simply helps us transition from the introductory part to the operative part. So what it does is to simply introduce the operative part of a deed of assignment. So let's look at how to draft the Testatum. In drafting the Testatum, it is drafted as now this deed witnesses as follows. Now this deed witnesses as follows. So if you have in your bar finance examination where the examiner directly says draft the Testatum to the final document to be executed between the parties mentioned in A above, your answer should be now this deed witnesses as follows. So let's try to feed this into the existing draft we already have. We've drafted the introductory part already, right? Where we did the commencement, the day, the parties, and the recitals. So given that we already have the introductory part, so now that we want to write the operative part, it's not as though you want to turn to another page entirely. So you simply write it beneath it. Now this deed witnesses as follows. And of course, when you look at the wordings of what we have, it simply means that it just further reinforces the fact that this particular deed of assignment serves as a conclusive evidence of whatever the parties have agreed in relation to the transaction. So please take note of that. That is the function of the Testatum. Now, the clause that follows the Testatum is the consideration clause. And of course, when you get to this point, you are very interested, right? Because consideration has to do with money or money's worth. And of course, everybody likes money. So, consideration or money's worth. And consideration in this context is what the assignee is giving to the assignor so that the assignor, in exchange of that money or money's worth, can transfer her interest. Jumoke Adebayo now can transfer her interest, her legal interest in land to Chief Adeola. So consideration can either be money or money's worth. We also mentioned during the mid-tutorial video that in the module 1, while giving you an overview of sale of land transaction, one of the things we mentioned is that consideration does not need to be adequate, but it needs to but what sufficient. So what that means is parties can agree that they want to sell 50 hectares of land for 5 naira. Now you must not say, how can they sell it for 5 naira? Consideration need not be adequate but sufficient. So say that I am an examiner and then I decide to give you a question that telling you that Chief Adeola wants to buy land from Jumoke Adebayo for, and he's buying like 100 hectares of land, and Chief Adeola is going to pay 10 naira. You know, some people would just say, sir, there's an issue with the question. The land is 50 hectares, but the amount you want to sell it is 10 naira. Now you must remember, consideration does not need to be what adequate. It needs to be what sufficient. As long as the assigned no, it's not complaining. There is no vitiating element saying that maybe there was fraud, misrepresentation, or mistake, or all of that. Whatever the assignor says, this is the price of what is what I want to collect. That is the consideration. Right. So there's no fault or error with the question because there's no vitiating element that the examiner said to you that maybe this person pressured this person on this, right? So consideration does not need to be adequate. Consideration only needs to be what sufficient. Sufficient in whose eyes? Sufficient in the eye of the what the assigned. No. So that is a general thing you need to know about consideration. Now, what then is now the function of the consideration clause in a deed of assignment? Number one is that it is used for the assessment of fees to be paid as stamp duty, registration fee, and other taxes. Now, you know that under the perfection, that is the post completion stage, right, where you have the governor's consent, stamping of the deed of assignment and registration, there are fees that the law requires to be paid. When you check the Nigerian Tax Act, right, you see that land transactions evidenced by instruments must be stamped, right, and then you need to pay. And of course, stamp duty in relation to land agreements and deed of assignment, as the case may be, is paid ad valorem. It's paid according to value. According to what value? The value in which the land was what sold. So this consideration clause, since it's about the money or money's worth, it is this consideration clause that will state the amount that the assignee paid to the assignor in order to get the legal interest in that land. That is to get the unexpired residue in that land transferred from the assignor to the assignee. So the tax master will look at the consideration. Oh, it's 400 million. Then he knows how much to charge based on the value of the land. So there's already a fixed percentage that should be paid. So it will be so percentage of 400 million because it's paid ad valorem. So it's paid according to the value of the land. So this consideration clause now helps the tax master see it and say, okay, this is the amount this person is to pay, right? So it is used to assess the fees that should be paid as stamp duty. The same applies for registration too, right? The consideration clause is what they would use to assess the fees to be paid. Now, the second function of a consideration clause, what it does in the deed of assignment is that it proves that the transaction is a sale and not a gift. It proves that the transaction is a sale and not a gift. In the main tutorial video, when we discussed the various mode of acquisition of land, one of the ways that a person in Nigeria can acquire land is via gift inter vivos, right? And in gift inter vivos, as the name implies, is a gift exchange between two living persons, right? Inter vivos, right? So when it is gift inter vivos, the donee of that particular gift is not paying anything. It's just free of charge. right? But in a sale, there must be consideration. Something moving from the assignee paid to the assignor. So if you create a sale of land agreement, sale of land, the deed of assignment, and there is no constitution clause, how then do you really prove that this was not really a gift? Because what if in the form is showing that it's a sale of land, right? But when we now look at it, there's nothing to show that something was paid by the assignor, by the assignee to the assignor. The court may interpret that document as, oh, well, maybe they will really, maybe it's a gift that has taken place. Maybe the lawyer did not know what to really draft. So to clear that misconception, the constitution clause helps to prove that this transaction is a sale. Something was paid by the assignee to the assignor. If this was a gift inter vivos, the donee does not need to pay anything to the donor, right? So this consideration clause helps to prove that this transaction, instant transaction, is a sale and not a gift. Now, another function is that it verifies the content of any subsequent issue receipt that is issued. So, for example, as we're going to see when we look at how to draft the consideration clause, since the consideration clause has clearly stated that Chief Adeola is paying 400 million naira. Therefore, if Jumoke Kehinde decides to issue a separate receipt to Chief Adeola, what should be there should also be what? 400 million. So it simply helps to verify the content of any subsequent receipt that is what? Issued. So let's look at how to draft the consideration clause. Remember, we have our testatum already, which is now this deed witnesses as what follows. So how then do you draft the consideration clause? First of all, you already know the consideration in the scenario. Let's look at it. When you look at the scenario, it says that the parties, right, have agreed to a price of what? 400 million naira. So the examiner has clearly given you what the consideration should be. So if you are now told now, let's say the question just asks you directly to draft the consideration clause. It's not for you to start saying, I'll just write any amount. So no, you've been told that it's 400 million naira, right? So how then do you draft it? In consideration of the sum of 400 million naira, then you put the amount in numbers in brackets, only paid by the assignee to the assignor. in consideration in consideration of the sum of 400 million naira, only paid by the assignee to the assignor. Now, if what I even gave you from the start was just this draft, you'll be able to deduce the fact that, oh, the assignee actually paid, the assignee is to pay 400 million naira to the assignor in relation to this sale of land transaction, and that this is not a gift because consideration is what involved, and parties have agreed that 400 million naira will be the amount to be paid so that the assignor can transfer his interest rather in land to the assignee. So this is how to draft the consideration clause. So take it to be that you are asked in the exam. You can see that if you can memorize this and practice it often, you get your mark straightforward. In consideration of the sum of 400 million naira only paid by the assignee to the assignor. So let's move to the next clause, which is the receipt clause. What then is the function of the receipt clause? We have just seen the consideration clause that shows us that this transaction is a sale, not a gift. We have seen that it is what the tax master will use to assess the fees to be paid. We have said it does not need to be adequate, it only needs to be what? Sufficient. It shows us that it is what parties have agreed to be paid. What then is the function of the receipt clause in a deed of assignment? The function of the receipt clause is how the assignor officially would acknowledge that the assignee has actually paid and that he, the assignor, has received that 400 million naira. It is possible that, if it is just about the consideration clause, it's just showing you that this is what I expect the assignor to, the assignee rather, to pay me. But when you now include the receipt clause, you are showing that he has paid. I have received it. So it serves as prima facie evidence that that purchase price of 400 million naira has been paid. That payment, you are confirming that you have received that payment of 400 million naira from Chief Adeola. So Jumoke Kehinde is confirming that by including a receipt clause. Therefore, it creates a rebuttable presumption of payment. It creates a rebuttable presumption of payment. Why are we saying that this presumption is rebuttable? It is possible that Chief Adiola eventually did not even pay the full 400 million naira. But just for the purpose of, let's just draft this deed of assignment so that parties can sign. Delivery will be in escrow, right? Since delivery will be in escrow, let's just write it that, okay, receipt of which we acknowledge. But don't forget, we can get to court. The court will presume that he paid. But you can now prove to the court that, see, delivery was in escrow. At the time we signed this deed, even when we wrote that he had paid 400 million naira and we received it, it was part payment he paid. All you have to do is to tender that evidence. Then the court will know that, okay, what you are trying to say is that the delivery of your interest was now in escrow. I know we already thought about that when we mentioned the issue of delivery. So it creates a rebuttable presumption of what? Payment. Now, the third function of the receipt clause is that it gives the purchaser solicitor the authority to pay money to the vendor's solicitor, right? Since we have already included the receipt clause, then the purchaser solicitor that might be in custody of the money, maybe he's acting as, maybe he has received that money as agent, then he receives that money to pay to the vendor solicitor. After all, we have included it that the receipt of which you have acknowledged, right? So you pay that money to the vendor's solicitor. Now, the last function is that the issuance of a separate receipt might become unnecessary. The issuance of a separate receipt might become unnecessary. Now, I'm going to help you a little bit, but you have to be very careful with what I'm about to tell you. So, because you must distinguish between when you are learning the law at the law school and then what you have in practice, right? Now, it is possible to draft a deed of assignment in practice and then you don't include a receipt clause. That is in practice. But don't apply this in law school. Don't say, okay, receipt clause is not necessary. So even if I don't write it, no, you should write it. But the fact that law school needs you to do something, then what if you are now in practice and receipt clause was not included? Would you now say, they taught us that the receipt clause must be there, it's not there, what do I do? Right? So it's possible that even when the constitution clause is there, there's no receipt clause, then the assignor can decide to issue a separate receipt. But when you actually include that receipt clause in the deed of assignment, you can dispense with not issuing any receipt, because since you have already said, because we're going to look at the draft now, the way to draft the receipt clause says, I have acknowledged I've received the money. So if I've acknowledged and this deed witnesses as follows, then why do I need to issue a separate receipt? But what if there is no receipt clause in that deed of assignment? Then the assignor can issue a separate receipt. But if you are told to draft the operative part, don't say, I'm not going to include the receipt clause. That one does not apply to you. It applies to you when you're not in practice. When you're in practice, you can do what you like, right? As long as you don't implicate your clients. Just ensure that you understand this position of the law. The issuance of a separate receipt might become unnecessary. So let's look at how to draft the receipt clause, because the receipt clause follows the consideration clause. So remember, you have your testatum again. This is witness as what follows, and then you now begin to write your, let's start with the consideration clause, because the receipt clause is side by side that consideration clause. So the consideration clause still says, in consideration of the sum of 400 million naira only paid by the assignor to the assignee. The receipt clause now says, the receipt of which the assignor hereby acknowledges. So you can see that now that you have seen the draft, it brings to memory all the functions we have mentioned. Since the draft says the receipt, I think the receipt of that 400 million naira, of which the assignor hereby what acknowledges. What's the implication? It means that we can tender this if maybe the assignor now says later that I was not paid, no money was paid by the by the assignee. You can tender the deed of assignment. You acknowledged that you received it, and of course, you tender the other transaction where you transferred. So, yeah, it has created a prima facie evidence, right? And also, since this is written this way, the issuance of a separate receipt might be what? Unnecessary, right? So, you take note of how to draft the receipt clause. The receipt of which the assignor hereby what? Acknowledges. So, this is how to draft the receipt clause. So, you can take note of that. You see side by side the consideration clause. The next clause that follows the receipt clause is what is known as the capacity clause. Is what is known as the capacity clause. The capacity clause answers the question of the status in which the assignor is conveying interest in land to the assignee. And that simply answers the question of the legal relationship of the assignor and the property that is to be transferred. So, what is the legal status of Jumoke Kehinde in relation to the land she is about to transfer to Chief Adeola? Very important for us to know this, the legal status, that is our capacity to be able to transfer that land to Chief Adeola, because the capacity clause is always coupled with implied covenants. That is, the moment she holds out to say, I'm transferring this land in this capacity, it comes with implied covenants. So you have to be very sure and certain of the capacity in which the assignor is transferring land to the assignee. So, in case you are wondering, in what capacity can the assignor convey interest in land to the assignee? Take note that an assignor can convey interest in land in the following capacity: either as beneficial owner of that land, as mortgagee, as executor, trustee, or personal representatives. Now, don't forget that we have said each of these capacity comes with implied covenant. So you have to be very sure. And it is not the assignor that will just say, you know what, I just feel like conveying this land as mortgagee. No. We're talking about your legal relationship with that land. Let me explain mortgagee, executor, and trustee. We'll come back to beneficial owner. Now, in relation to mortgagee, in what context are we going to say that an assignor is conveying interest in land as a mortgagee? Now, take your mind back to mortgage transaction that we explained. We said in a mortgage transaction, the mortgagor approached the mortgagee to take to obtain loan, right, in exchange of legal interest or equitable interest in land belonging to the mortgagor, right? The essence of the transaction initially is not that the mortgagee takes ownership of the land. It is just so that you can use that interest in land to secure that obligation or to secure the repayment of that loan that the mortgagee has advanced to the mortgagor. So let's take it to be that the mortgagor now defaulted in repaying back the loan advanced to him by the mortgagee. Now the mortgagee wants to exercise his power of sale, because one of the rights available to the mortgagee in a mortgage transaction is the power of sale. So now he wants to exercise that power of sale. So let's say that the mortgage transaction was between Mr. A and B. Mr. A being the mortgagor, Mr. B being the mortgagee. Mr. A being the mortgagor now is in default. He has not paid. Now, Mr. B, the mortgagee, wants to exercise the power of sale. When you say power of sale, then you're talking about a sale of land transaction. That is, Mr. B now, the mortgagee, can then go ahead to sell the land. When Mr. B, the mortgagee, is about to sell the land to Mr. C, the transaction between Mr. B and C is a sale of land transaction. The transaction between Mr. A and B is a mortgage transaction. So now, Mr. B wants to sell to Mr. C. In what capacity, therefore, is Mr. B selling to Mr. C? He is selling in his capacity as mortgagee. Why? Because how, in the first place, the only right that gave Mr. B to be able to sell the land is that mortgage transaction. Therefore, he's selling in his capacity as mortgagee. So let's say, for example, I pick up a deed of assignment, right? Mr. B in this second transaction now. No, Mr. B will be assignor. Mr. C will be assignee. When I get to the capacity clause, what I will see is that the assignor is conveying as mortgagee. The moment I see that phrase, it implies that, okay, somebody, Mr. B is not the beneficial owner of the land, right? The reason why he has the right to sell this land is because somebody, Mr. A, defaulted to pay him, is exercising the power of what? Sale. So you can see that this capacity clause comes with what? Implications, right? What about being an executor? The example, it just follows. Who is an executor? The executor is the persons, right, that administer the estate of a deceased person, right, that has been appointed by the testator. So where the testator in a will, right, says, in this my will, my executors must sell my land at so at XYZ. The executors are meant to execute, administer the wish of the testator. So now, let's say that Mr. B, or let's not use B so that it does not confuse you. Mr. K, right, was appointed as executor to administer the will, right, of a testator. Now, that testator in his will now says, okay, sell my land. And when you sell the land, give the proceed of the sale to so and so. Now, when you are now involved in that sale of land transaction, that Mr. K, right, becomes the assignor. Of course, in what capacity is he now selling the land? He is selling the land not as beneficial owner, because the land does not belong to him from the first place. Not as mortgagee, because we're not talking about a mortgage transaction. He is selling the land in his capacity as the executor of the will of a testator. So what will be his capacity? What will be contained in his capacity clause is that the assignor is conveying as executor. So the moment you see that phrase, it tells you immediately that, okay, these assignors, they are not the beneficial owner of the land. The only authority they had to sell this land was because the testator had told them to sell it. So they are selling the land in adherence to what the will of the testator has what said. The same thing applies to trustee. There is a beneficiary. So the trustee is acting in the benefit of the beneficiary, right? He's holding that property on the benefit, right, of the beneficiary. So when he's selling, is to only know the trustee is only to act at the pleasure of the beneficiary. So the trustee is selling because the beneficiary is aware, and anything that takes place in this transaction is on behalf of the beneficiary. So because the beneficiary cannot personally carry out the transaction, but he needs a trustee in that arrangement. So the moment you see that capacity clause, you can understand how the legal status of the assignor in relation to that land. Of course, for personal representatives, we just use this so that we could have written administrators, right? But because personal representative is an omnibus word for both executors and administrators, that's why we just used it as personal representatives. So what if a person died intestate? He died without making a will. Well, because he died without making a will does not mean his estate must not be administered. Administrators are appointed to then. So if those administrators decide to sell, they are selling in the capacity as what? Administrators or personal representatives. So let's go back to the first one, which is beneficial owner. So this one now, very simple and straightforward. Why? Because how do you know the meaning of beneficial owner? Of course, you have already seen the word owner. Simply means that this person probably bought the land. It's his land. It belongs to him. So because he's selling as a beneficial owner, it comes with the following implication. But I can give you for free that this implication gives you the meaning of beneficial owner. So let's look at the implication of the assignor conveying the land as beneficial owner. The first thing you are telling the assignee by implication, that is, the moment you hold out that, see, oh, I am the beneficial owner of this land, impliedly you have told the assignee that you have the right to convey. 2, that the assignee will enjoy peaceful and quiet possession of the land. You are also saying that this land, this property is free from encumbrances. You said it's your land now. So if it belongs to you, then it means if you are transferring it to the assignee, it's to have peaceful and quiet possession. That means nobody will come to say it's my land. Nobody will, a third party will not come to claim it, right? Since you said it's your land as beneficial owner, it means you have the right to convey. You don't need authority from any other third party before you can what? Convey it. And you're also saying that you are even assuring the assignee that if there's anything, right, you are indemnifying him, right, in the event that a third party now comes to say, I want to lay claim to this land. So if for any reason the maybe the assignee now is taken to court and then a third party now claims title and then he won, you can sue to recover the purchase price because you have been indemnified by the assigned. No. However, note that where the property that is to be conveyed is covered by a certificate of occupancy. Because when you look at our scenario, you notice that in that our scenario, the land in question, we said that it was covered by a certificate of occupancy, registered as number this page, that volume dash. Now that it's covered by certificate of occupancy, where that same property is now being conveyed as beneficial owner, then it comes with these implications. It comes with this implication. Jumoke Kehinde is conveying this land as beneficial owner because the deed of assent is vesting this title on her as a new beneficial owner. Nobody else is coming to claim it, right? So, and the land is covered by C of O. How would you know if the land is covered by C of O? The examiner will tell you. So there's nothing like how would I know? It will be clearly written. It's covered with certificate of occupancy. So since it's covered with certificate of occupancy, then you are now asked because the examiner can ask you. He might not ask you to draft anything. He might just say, in what capacity is the assignor conveying? Then you said, oh, the capacity in which the assignor is conveying is beneficial owner. There, Jumoke Kehinde haven't been invested by deed of assent is the beneficial owner of in respect of the land situated as number dash and dash. Then the question that follows now says, state the implication. You won't only state this for. You have to add that the lease is valid and subsisting. What lease? We have said that when the land is covered by certificate of occupancy, technically speaking, the land belongs to the governor. Anybody who is a beneficial owner now is the lessor. So the governor the governor is the lessor. The person holding that land as beneficial owner is the lessee. So the lease between the governor and the person in possession of the land is a lease. So the lease is valid and subsisting. Is in relation to that relationship between the governor and the person holding title to that land. And also that all rent has been paid and obligation in the lease has been performed. What lease? The one between the governor and the beneficial owner. The rent we're talking about, they are all the payment, all the fees, all the dues, and the levies that you should have paid. All those ground rent and all of that in relation to your relationship with the governor. So please take note of this implication of conveying as beneficial owner. And please be careful. The moment you see that the land is covered by certificate of occupancy, you are not only writing 4 implication. The implication you must write must be 6. It is not compulsory, it must be 6. What you first find out is the land covered by certificate of occupancy? If it is covered by certificate of occupancy, then you know to write 6. If it is not covered by certificate of occupancy, you write 4. So you take note of that. So how then do we draft the capacity clause? We have our testatum, right? And so let's begin with our consideration clause. Because they are together, that's why we don't have a choice. We just have to write the consideration clause first, and then it follows with the receipt clause, right? He has acknowledged it. Here you now see the assignor as beneficial owner. The assignor as beneficial owner. How did we arrive that Jumoke Kehinde is conveyed as beneficial owner? Because it's not about mortgage here. Jumoke Kehinde is not an executor. She's not a partner representative. She's not a trustee. The land was willed to her by her late father. Then the executors executed a deed of assent to vest title on her. So now she's the beneficial owner of the land. So that is why we have written it as the assignor as beneficial owner. So how do you draft the capacity clause? It's not about just drafting. It's to first quickly establish in what is legal relationship of this person in relation to the land. So the assignor as beneficial owner. What if it was a mortgage transaction? The assignor as mortgagee is now conveying the land. So that is how to draft the capacity clause. The next clause that follows the capacity clause is the words of grant. The words of grant. Now, this word of grant, very simple and straightforward. What it does is that it states the legal intention of the party who is transferring the property. For me, I would explain to you that it's like a verb that captures what party A is doing to party B. It's a sale of land transaction. So you are saying, in one word, tell me what the assignor is doing to the assignee. Give me that one word. That is what this word of grant does. It's like an action word that captures the legal intention of the party who is transferring the property. So if I were to ask you, what is the purpose of a deed of assignment? It is to what? Assign. What is the purpose of a lease? It is to demise. What's the purpose of a sublease? It is to subdemise. What is the purpose of a mortgage? In our own context, it is to charge, right? Based on the way to draft it. The mortgagee by charge, so. But why we have chosen to use charges, because we know that there are different ways of creating legal mortgage, right? We know that there's one by assignment and all of that. But let's just stick with this, just for the purpose of what? Clarity. When you look at the mortgage video, you would see the various ways to create a mortgage transaction. One of it is by way of charge. That is why we have used the word charge, not because it's the only way to do it, right? So you can see that this word of grant is just capturing what the party A is doing to the party B. What is the assignor doing to the assignee? He is assigning. That's all. So imagine a question says, draft the word of grant. You see, it just says, we're going to say how to draft it, but it is just a word that captures what the party A is doing to party B. So in a lease, you are demising. In a sublease, you are subdemising. So in so you look at that as very, very what? Very simple. So let's see how to draft the words of grant. So like I said, these draft, they are together, right? So that is why we don't have a choice. We have written the testatum, we begin to write the consideration clause again, in consideration of the sum of 400 million naira only paid by the assignee to the assignor, the receipt of which the assignor hereby what? Acknowledges. The assignor as beneficial owner assigns. So if you are asked to draft the word of grant in that final document that is executed between Chief Adeola and Jumoke Kehinde, your simple answer is assigns. That's all. That's all, because that's the word of grant. What is the party A doing to party B is assigning. So the assignor as beneficial owner, the assignor as beneficial owner is capacity clause. Assigns is the words of grant. Since this aspect of the operative part is very interesting and very simple and straightforward. Once you just understand the logic and the flow from the consideration, you don't have to memorize how much is he paying. 400 million naira. Have you gotten it? Yes. What's your capacity as what? As beneficial owner. What are you doing? You are assigning. Once you use that logic, you'll be able to what? Memorize it. So the next clause that follows is the all that clause. All that clause. What is the function of the all that clause? The function of the all that clause is to introduce the parcel clause. Very funny, right? Because after the all that clause, you have the parcel clause. So the function of the all that clause is to introduce you to the parcel clause. And one of the job it does is that it's signaling to you that whatever we're going to write in that parcel clause, it is everything in this parcel clause that the assignor is conveying to the assignee without reserving any part to himself. So the agreement orally was to buy a plot of land. That plot of land has an address, has a location, right? We are now saying it is all that one plot we are giving you. What that means is that it is all the one plot. So I'm not reserving any part to myself. I'm not saying inside this one plot, Jumoke Kehinde is not saying in this one plot I still have something there. No, you are assigning to me. Don't forget the words of grant. You are assigning all that what? That's the parcel clause. So it tells us that I am giving you everything. Whatever I will mention this parcel clause, I am giving you everything without keeping anything or reserving any part of it to myself. So let's look at how to draft the all that clause. Very simple too, right? So remember you have your testatum, right? And then followed by your consideration clause, right? In consideration of the sum of 400 million naira paid by the assignee to the assignor, the receipt of which the assignor hereby acknowledges the assignor. Remember your capacity clause, as beneficial owner assigns all that. That's all. All that. So imagine somebody is asked to draft the all that clause. Even the answer is in the question. All that. That's the answer. All that. You know, don't forget, you know the clauses. So if you are asked to draft a clause, you don't have to go and draft everything. If I say draft the constitution clause and I'm drafting the receipt clause, that's just surplus. Draft the constitution clause is draft constitution clause. Draft all that clause is draft all that clause. The answer is all that. Don't be skeptical to say, will it be correct? Yes, it's a clause. It's already fixed in law. The clause is the clause. All that clause. So the clause that follows the all that clause is what? The parcel clause. So let's talk about the parcel clause. The parcel clause, of course, what it does is that it gives you the identity of the land. First thing first, why are we involved in a sale of land transaction? It's because there is a land to be sold. And that land has a fixed dimension. Every land should have a fixed dimension. So the parcel clause helps you to uniquely identify the property as to address and size. You know, lands are everywhere, right? But they are owned, right? So there should be a demarcation that says, oh, your land, Mr. A's land is from this place to this portion to this portion. This is the square meter of Mr. A's land. This is the square meter of Mr. B's land. Mr. A cannot just say, I want to sell the property to you. Where is the property? Don't worry, it's just a land. What do you mean by just a land? You have to be able to locate the property. So the parcel clause helps you to uniquely identify that property as distinct from the property belonging to somebody else, so that the third party will not come later to say, this is my property now. So in order to distinguish the property of Jumoke Kehinde from any third party's property, you can say this is what the property to be sold to Chief Adeola, right? And it must contain the registration details if it has been registered or surveyed, right? Of course, not everybody has registered their land, but they ought to have. But the moment you are conveying and you know you have registered the land, include it. So you can include the registration details of the property if it has been registered or it has been what? Surveyed. So it is in this is in this parcel clause. You can also have the survey plan of the land, you know, quoted in as in relation to, okay, this is, we have surveyed the land. These are the dimension, right? The square meter. Then I told you during the main class that how land is measured in Nigeria is square meter. You can just note that. Who knows? Maybe they will just ask you in MCQ, right? So land is measured in Nigeria in square meters. Any other measurement is void ab initio, right? So land is measured in Nigeria in square meters. So it describes the physical boundary, the address, the size, and the registration details of the land, so that you won't confuse it with any other piece of land in the world. So let's see how to draft the parcel clause. Once again, we have our testatum followed by our consideration clause. So in consideration of sum of 100 million naira only, paid by the assignee to the assignor, the receipt of which the assignor hereby acknowledges. The assignor as beneficial owner assigns all that parcel of land lying and situate at number 5 Niger Street, Uze Zone 5, Abuja, covered by certificate of occupancy number 49, page 59, volume 218, and more rightly described in the survey plan to be prepared by a licensed surveyor attached to the schedule, with all rights, easements, and appurtenances. So here now you have a sample of the parcel clause. You can see that in this parcel clause, it's specific about where the land is lying and what situate at a particular address. So when you look at this scenario, the scenario has told you where the land is located. The land is located at number 5 Niger Street, Uze Zone 5, Abuja. You must include that in the parcel clause, so that if for any reason there is a dispute, The location of the land will not be an issue again, because in law, where there is a land dispute and the exact location of where the land is not an issue, then there's nothing to join issues to. It's not there's no need to say you are raising that as a point of issue that the parties need to know where the land is. You don't If parties are not at a variance as to where the land is located, that's not an issue in a sense of land dispute, right? Maybe they are disputing other things, but they are not disputing the exact location of the land. So that helps you in if where dispute what arises. So how you know the parcel clause, the address, is to look at your scenario. But what if you are not given an address? You can improvise. But if you have been given an address, you stick with the address in your scenario. Don't improvise. The address has been given to you, you don't improvise. But if it was not given to you, you can what? Improvise. So you can see here that it has also stated that the land is covered by certificate of occupancy, signifying that it has been registered and that it comes with a C of O, right? And then you have clearly what stated it. Then you now said, and more rightly so described in the survey plan to be prepared by licensed surveyor attached to the schedule with all rights, easement, and appurtenances. Now, why this can be there is because not every land has been surveyed. But you are now saying that, now watch what I'm about to say. You are now saying that, see, oh, this land, this is the location of the land. But right now, while we are making this deed of assignment and transacting, we don't know the exact dimension of the land. But we are saying that whatever is now contained in the survey plan that will be prepared by a licensed surveyor will be taken as the exact measurement and dimension of the land. But we know where the land is, but we don't know the dimension, right? But what if the dimension is known? Then you include it. It will have been included in that line associated at number 5 being measurement of so and so by square meters and then you'll be able to write that. That also depends on what the scenario what tells you. So this is how to draft the parcel clause. The parcel clause. Now, the next clause that then follows after the parcel clause, which is the final clause, is the addendum. The addendum, right? And what then is the function of the addendum? The function of the addendum is to simply define the extent of interest that is being transferred to the other party. Now the reason why sometimes you are seeing me write other parties is that some of these clauses they also reflect in other, like if you are writing a deed of if you are drafting a deed of lease now, there's also an addendum to it, right? So I can kind of give you the general function, but now zero it into deed of assignment. So the function of the addendum is to define that extent of interest being transferred from party A to party B. Now, since this is a deed of assignment, in relation to a sale of land transaction, the party A is assigning all her unexpired residue in that land to the other party, that is the assignor to the assignee. So the addendum will capture that fact that the assignor is giving her is giving out everything to the assignee. But what if we are talking about a lease, which is what we have as our next point, that the addendum can help you differentiate the type of transaction in view. Where an addendum appears in a lease, the way it is drafted will let you know that this transaction is a lease, because it will be drafted in such a way that will let you know that the lessor still has a reversionary interest, even though it's conveying an interest to the lessee. There is still reversionary interest. Why? In a sale of land, interest is being conveyed. In a lease, interest is also being conveyed. So the addendum helps you differentiate between a sale of land and a lease in that sense, based on what we have explained. The way it is drafted helps you know, okay, this is a sale of land transaction. When it is drafted in a particular way, you will know that, okay, this is a lease. So when we talk about deed of lease, we'll see how to draft that addendum in that context. Now, for the purpose of MCQ, addendum is not compulsory in a deed of assignment, but you must include it in a lease. Let me repeat what I said. For the purpose of MCQ, addendum is not an important clause in a deed of assignment. It's not compulsory, but it is compulsory in a lease. Like I said, this is just strictly for MCQ purpose. So let's see how to draft the addendum, which is the last clause in the operative part of a deed of assignment. So, in consideration of the sum of 400 million naira only paid by the assignee to the assignor, the receipt of which the assignor hereby acknowledges, the assignor as beneficial owner assigns all that parcel of land lying and situate at number 5 Niger Street, letting us the parcel clause, right? Those as we just discussed. Then it has told you, and to be more rightly described in the survey plan to be prepared by licensed surveyor. If you know the name of the surveyor at time of, you can also include it. Appurtenances to hold onto the assignee the unexpired residue of the term of years in the certificate of occupancy. So you can see that the way to draft the addendum. So all you now have to hold on to the assignee the unexpired residue of the term of years in the certificate of occupancy. So you are saying this addendum is capturing the fact that the assignor is assigning all the remaining number of years in this certificate of occupancy to the assigned. That is, the assignor is doing that to the assignee because of the way this has been drafted. If it was a lease, the way to draft it will show that, oh, you're only conveying so number of years, 5 years, 10 years, and that it captures the fact that there will be reversionary what interest back to the lessor. But an addendum function in the deed of assignment is to confirm the fact that this is a sale of land where the assignor is divesting herself of all the number of years left in certificate of occupancy or in the interest of land to be given to the assignee. So this is how to draft the addendum. So you can see that the operative part of a deed, I often tell people that it's very simple. You just have to follow the sequence. So now this will be as follows, right? To evidence that whatever we are doing now is binding on us. What is binding on us? Money. I paid. This is the amount you have asked me to pay. I have paid. Receipt clause. But yeah, what capacity are you conveying as beneficial owner? What are you doing? You are assigning what? All that. All that what? Parcel clause. When you are done, how do you really show me that this is a sale of land? Addendum. So you can see that just instead of cramming it, try to make it flow logically in your brain. That, oh, I have done the introductory part. I have introduced the transaction. I have mentioned the date. I have included the parties. I have recited how this person got title and all of that. Now I'm going to the operative part. In the operative part, it will show me that this deed is enforceable. We can tender it as evidence in court. Okay, what did we evidence? I paid. This amount I should pay. I paid. Right? Then the assigner told me is transferring to me as what? Beneficial owner. What is he doing to me? Is assigning. What is he assigning? All that. All that what? Parcel clause. How then do I know that it's a sale of land? Includes the addendum. Right? So this is all you need to know about the operative part of a deed of assignment. So in the next video, what we're going to discuss is the miscellaneous part, where we'll talk about the indemnity clause and the acknowledgement and undertaking for safe custody. Please, if you are here to subscribe to our YouTube channel, please do so. And if you are also here to recommend us to your friends, please also do so. Right? You can follow us on other social media platforms. We're on LinkedIn, we're on X, and of course, like our post on YouTube also. So I'll see you in the next lecture video.